If you're wondering what this show is about, I can tell you in one word: freedom. And freedom of speech, in my opinion, is one of the most important freedoms. That freedom got an unexpected boost, or maybe it was expected this week by, of all people, the Supreme Court of Canada. And joining me now is my friend Alan Shanoff. Many years the defamation lawyer here at the Toronto Sun, columnist for the Sun, and you teach a little bit of law here.
Yeah, I teach media law at Humber College.
I'm very glad you're here because just this week the Supreme Court brought down a ruling about defamation on the internet and whether or not just linking to something can make you liable for defamation. Tell me about this case, and is it good news for freedom lovers like me?
Well, it's great news for someone like you because I know that you like freedom of expression, and this case broadens freedom of expression for everybody. Hyperlinks are ubiquitous on the internet. You can rarely go to a page without seeing a hyperlink. They're fabulous.
That's just the thing you click to take you to another page.
Exactly. Presto, you're on another page. You get all sorts of background information, some of which you may agree with, some of which you may disagree with, some of which you may know nothing about. The question is, if you have that hyperlink on your page, are you yourself responsible for the content on that hyperlinked page?
And this isn't just for bloggers. Anyone who has a link on Facebook, anyone who sends a joke around the office, they are actually linking whether they know it or not.
That's right, because defamation law applies to everything from newspapers, magazines, broadcasts, tweets, Facebook, your personal blogs, your emails that you send out to people.
Even a text message.
Everything.
So tell me about this case. What's the case called, first of all?
The case is called Crookes versus Newton.
Is it important who the people were, or is it the principle that matters?
People are irrelevant to this case.
This is the law. This is the highest court of the land, so it can't be appealed from here. This is the law that's going to set the standard for years to come.
Cannot be appealed, and even with 2 new members of the Supreme Court of Canada coming on this fall, we're not going to see a change to this law.
So break it down for me. What was the status of the law before this week, and how is freedom strengthened now?
Well, as part of defamation law, you're liable when you're deemed to have communicated something or published something. And if you make something available to a third party, you've published it and you become liable for it.
Even if you just published it to one single other person, that's called publishing in defamation law.
Publishing to anybody beyond the person that you're talking about is a communication or publication.
Okay. So what other way could this case have gone?
Well, I think what a lot of lawyers thought before this case was ever argued was that if you put a hyperlink on a page, you make something readily available, readily accessible, and therefore you've communicated anything on the underlying hyperlinked page, thereby becoming responsible for it. What the Supreme Court of Canada did in this case was say, no, we're not going to apply that law. And I can read you a quote from the case.
Please
which
do.
I think is
You brought
very
some law
important.
talk. You brought a law talking book here too.
I brought the.
You're one of those lawyers who actually reads those thick books.
I've got my Martin's Criminal Code because I want to spring something else on you.
Okay, well, let's go with the quote from the case first, and then we'll talk about the criminal code.
Okay, so this is what the majority of the Supreme Court of Canada said. The Internet cannot provide access to information without hyperlinks. Limiting their usefulness by subjecting them to the traditional publication rule would have the effect of seriously restricting the flow of information and, as a result, freedom of expression, your favorite phrase. The potential chill in how the Internet functions could be devastating, since primary article authors would unlikely want to risk liability for linking to another article over whose changeable content they have no control. Given the core significance of the role of hyperlinking to the Internet, we risk impairing its whole functioning. Strict application of the publication rule in these circumstances would be like trying to fit a square, archaic peg into the hexagonal hole of modernity.
Well, I mean, that's the whole basis of the Internet. It is a network. Everything connects to everything. I mean, Google would have to be shut down immediately because all Google is links, right?
Exactly. Now, that's where I get to the point that I want to spring on you.
Okay, I'm ready to be sprung.
Okay. Aside from what's going on in the Supreme Court of Canada, where we're seeing freedom of expression being broadened, we have our federal government, our Conservative government, introducing an omnibus crime bill, in which case they're trying to modernize some of our laws.
Right.
And they're trying to modernize our hate speech laws. Now, I've no brief in favor of hate speech any more than anybody else does. Problem with hate speech is trying to determine what it is. When you're inciting violence, great.
Uttering death threats, those are things that we have a clear definition.
That's right.
But hate's just a human emotion.
That's right. Now,
I hate how I look in these pants, for example.
Well, I won't comment.
Okay.
But the criminal code in section 319, subsection 2, has a criminal offense for communicating statements where you willfully promote hatred against an identifiable group. And if you do that, you can be convicted of an indictable offense, and you're liable to imprisonment for a term not exceeding 2 years.
That's why I'm glad you're here, because there is no doubt in my mind I will one day be charged under that, Alan. I hope you'll come and help me keep me out of jail.
I'll do my best.
Now, what you're saying is there's a contradiction between the criminal code here. The government wants to add internet linking to this provision of the criminal code.
Exactly. This provision deals with communication. And the question is, what is a communication? The government, in its omnibus crime bill, in modernizing the law, is telling us that a hyperlink is a form of communication.
I hope they don't introduce that provision to amend the criminal code, and I'm hoping the Supreme Court ruling will shake them out of their censorship stupor. I've been hard on the government on censorship, Alan, and hopefully the Supreme Court will help give them an attitude readjustment. Time goes too quickly, my friend. I hope you will join us again, because you bring the smarts in the law. I'm glad you're here today.
Thank you.